If you die without a will, the state will take your property. Really? No. We'll talk about simple wills right now on The Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar and the Monongalia County Bar Association.
Wills need not be expensive, they don't need to be complex, but they do need to be carefully written. My guest is attorney Robert Fisher. Rob, thank you for coming back. It's been a while since you've been here.
I'm glad to be here. Good to see you again.
People sometimes wonder, I think, where topics for this show comes from, and today we want to talk about wills, and particularly simple wills. And it stems from a telephone call that you and I had several weeks ago.
That's correct.
We were just talking about issues, and this one came up, and we decided to do a show on it. When we talk about wills, we tend to classify wills into wills and estate planning. What's a simple will?
A simple will is a will for the everyday person. It takes care of the decisions that you want to have made after you're gone, after you've passed away. You want to make sure your spouse is taken care of. You want to make sure your children are taken care of. You may have specific items of personal property that you want to make sure family members or friends receive. So all of those things are going to happen, and you're not going to be here to make those happen. So you put those into what we call a simple will. Estate planning is more complex. It involves usually millions of dollars, at least hundreds of thousands of dollars. A simple will is more for the everyday West Virginian, in my opinion.
Well, what happens if the ordinary person, the average man or woman, dies without a will in West Virginia?
Well, everybody in West Virginia thinks that the state is going to take it. The state of West Virginia is going to take it. And I'm really happy they think that, because they come in to see me, they sit down in front of my desk and they say, I'm here to make sure the state doesn't take my property. So I immediately tell them, that's not going to happen, but I am glad you came. And if that's what it took, if it took that sentence to scare you into coming, I'm glad you're here.
Have you ever seen the state come in and take somebody's property?
Absolutely not. The issue is the state will tell where your estate's going to go. If you don't have a will, it will dictate where your estate goes.
I actually saw the state take a person's assets who died without a will, but that was a very, very unique circumstance. It was a woman who had come to the United States from somewhere in Europe, nobody was quite sure where, who had no children, no spouse, no brothers, no sisters that anybody could identify. And as I said, they didn't know from where she came. So all that could happen was when she passed away, there was a notice in the paper that said she died. She owned a piece of real estate. Nobody ever came forward to identify themselves. And under those circumstances, the property ultimately passed to the state of West Virginia, and the state promptly turned around and tried to get rid of it because they didn't want to own it. But that's the only time in 32 years that I've seen that happen.
No, I've had it where there was missing heirs that you cannot run them down, so their share of the estate goes escheats to the state of West Virginia. But I've never had an entire estate go like you just said.
And it's a long and involved process before that happens. The state does not want your estate. They want your relatives, heirs, friends, neighbors, generally people that you identify, to have them. And there's very good reason for that, because whoever owns your property pays taxes on it, and the state of West Virginia wants tax money, and it makes sense to have it in the hands of private individuals if they can get it there.
I agree.
So who would your estate pass to if you were to die without a will?
If you die without a will and you've been married once, now the law is everything goes to your spouse. If you're married at the time of your death, even if you have children, in the old days, it went to your children, and your wife had a dower interest and certain interests like that. But under the more recent change of the law, once married, it all goes to your spouse.
The concept of dower is an older concept now that's fallen out of favor most everywhere. And that basically was the surviving spouse gets the mansion house, the last residence, some land around it, the income from other parts of the estate, to make sure, usually it was the widow, to make sure that the widow was provided for after her husband's death. Now all of that has changed. The widow gets a certain part of the estate, and that depends on the length of the marriage, frankly.
Yes. So depending on how many years you've been married, you get a certain percentage of the estate. Now, if you've been married once, 100% goes to your spouse. But if you've been married more than once, it can be 50% to the spouse and 50% to your children. And then if you have more than one spouse and have more than one set of children, you get into all those issues and get very messy very quick.
And this is why we encourage people to see attorneys. In the 21st century, it is not at all uncommon to find that people have had more than one marriage, more than one relationship that has produced children. We discovered around about 1980 that it's not necessary to be married to have children, and people have children, sometimes by many relationships. And so the law was amended to provide for that. But it's a very complex arrangement, and it requires some fairly sophisticated thinking about how you want to do things to make sure that things work out right. If you write a will, and if you don't write a will, the state's done that thinking for you, and they just kind of adopt a one-size-fits-all policy.
And it's usually not what you want, especially if you have infant children. If you have infant children and you know who you want to raise those children, if you die without a will, probably who you want to raise them won't be the right people, because they're just going to get together and pick someone if you don't have it in your will.
Yeah. Now, don't panic. If the children's other parent is still alive,
that's right.
That's where that's going to go. If you and your wife have infant children and you die and the wife survives, the wife is going to be the person who raises the children. And conversely, if the husband lives and the wife is the one who dies, the husband's going to be the one who raises the children. The problem is if both of you die catastrophically together in an automobile accident, in a plane crash, and these things do happen, then where are the children going to go? And unfortunately, you may find that there's going to be a tussle over that. There are two sides of the family. There's his side of the family and her side of the family, and both believe that they are the best side of the family.
Right.
And rightfully so, probably, but logically it doesn't work out that way.
So then they end up in court and spending a lot of money on lawyers to decide who's going to raise those children, as you say, on the simultaneous death of both parents.
And the way the state divides your property after your death, if you don't have a will, is basically to say, here is the category of people who receive your property, but it doesn't say who gets grandpa's watch and who gets grandma's quilts. They just say, give it all to these people. And then you have to divide it up, or they have to divide it up. And that, again, sometimes leads to hiring lawyers and going to court, and you can avoid all of that.
One of the messiest situations is if you have the stepmother getting 50% of the estate and the stepchildren getting 50% of the estate when dad dies, husband dies, and now they don't get along, and then you're really in trouble. And that's when you get lots of lawyers involved, because the stepchildren hire lawyers, stepmother has to hire lawyers, and they're all fighting over dad's estate.
That's right. The only people that inherit from your estate if you die without a will are your surviving spouse and your natural children. That's okay. Most people prefer that to some degree. The problem is if you die and your surviving spouse inherits from you and then your surviving spouse passes away, then that spouse's children, who may not be your children, are going to inherit perhaps a significant part of your estate, whatever their mother had at the time of her death. And frankly, most people do not want to plan their estates that way, to
That's
have
right.
property passing to people that they may not even know, let alone be related to. So you cure all of that by writing a
simple will.
What do you do there?
Okay, the best way to approach writing a will and going in to meet with a lawyer is to have a plan. What I like, when people call up and say, I want to talk to Rob about a will, the secretaries already know what to tell them to bring. To come to a will appointment, bring a simple list of your assets. Don't tell me every checking account you have, but give me a general list of what kind of assets you have, real estate that you own, who you own it with or don't own it with, cars, how they're titled, checking accounts, savings accounts. I want to know how everything is titled so we know what's going to go to somebody else whose name is on the account, what is in your name only. Bring me names of all your children, all your the people that you want to receive your estate, real names. If Bubby's name is Robert, bring me Robert's name and not Bubby, It's amazing how many people don't know their grandchildren's names, real names, for instance. Also, be thinking about who you want as executor. We're going to get into this. I'm sure you're not going to get this a little bit about what an executor does, but be thinking about who is going to take care of your estate, enclosing your estate. Who do you want to raise your children if you and your spouse are killed together or the second spouse dies? If you have specific bequests, if there's items of property that you want to go, the jewelry you want to go to your grandchildren, or the gun you want to go to your best friend, bring those ideas to me, because the appointment goes so much quicker and easier if you've given me those ideas ahead of time and have them listed on a piece of paper. And it's amazing how well prepared they come.
Is it necessary to list everything you own?
No. I recommend that you not do that. If you come in and you say, I want to give something to, I have 25 items I want to give, I then recommend there's a provision that you can put in your will where you can say, I have a list. It's attached to this will, and that list can change. You can change it all the time. You can change that list every week if you want to, and add to it and take from it, so that is a moving target. It'll be attached to your will as an addendum. It's part of your will, but it is not in the body of the will, so that it's very flexible, fluid, and changes as your personal. That's personal bequests only. Personal tangible property, touchy-feely property. That's what I like to see on the list.
Is that a binding list?
Yes. There's a provision you can put in your will. It's a long provision, don't get me wrong. It takes about a page to do it, but it talks all about how there'll be a list in your handwriting, dated and signed by you, that is meant to be part of your will. And you can change that list as you want to.
So that's handwritten.
Yes. Do not type it, handwrite it.
Sign it and
Date it, because that list will change. If you change the list, I like you to remove the other list, put the new list in. That's, at least I'm doing it, and I know other lawyers do it as well. That's something that the client can change and not have to come running back into the lawyer's office every day. They buy something new and different.
Okay. At what point does a will stop being a simple will?
Well, it all depends on which lawyer you're talking to. Most lawyers would define a simple will as a will where you're leaving everything to your spouse, to your children, naming some guardians if you have infant children, and executors. That's about what a simple will would be defined as. When they come in and they start getting into, well, I want to leave my grandchildren $10,000 each, and they can't have it till they turn 21. It's just going from simple to complex, and it's going to have trust provisions, and once you get into trust, you're getting into complex.
Yeah, when I think of a simple will, I typically think of, I leave it all to my spouse. If my spouse predeceases me, that is dead at the time I pass away, then I leave it in equal shares to my children. And if we get beyond that, maybe one or two specific bequests, but if we get into a list of things, I leave the cups to Mary and the saucers to Tom, and I leave this car to that one and this car to the other one. Now it stops being simple simply because of the labor that goes into listing all of these things and making sure you've got the names and the items properly described. Typically in a simple will, it'll say something like, I leave everything I've got to Tom, Dick, and Mary, and they are to divide it among themselves, and if they can't agree on how to divide it, my executor is going to agree for them and tell them what they get, and it's to be more or less in equal shares. And that's about where simple will stops.
Let me clarify one thing on specific bequests I want to make sure of. That list thing I talked about, that's if you got a long list. If you've got just lots and lots of stuff, and you're going to change it. Mm-hmm. If you tell me the Ruger pistol is going to forever go to your brother Bob, then we're going to put it in the will. So I want to clarify that for the public, that if there's items that will never change, you know that. Then let's go ahead and put them in the will. I don't do the list except when they tell me they're going to move it around a lot.
Yeah, and items of particular value, you would like to have that in the body of the will.
Yes.
If you've got Chippendale chairs or something, you want to put that in the will, or if you've got expensive and very particularized equipment, photographic equipment or something like that, or a collection of expensive or valuable quilts, things like that. You may want to put that in the body of your will also. We've mentioned several times the executor. What's an executor?
It is the executor's job to what we call settle the estate. To settle the estate, and I want to clarify this as well. We talk about probating the will. We talk about probate all the time, the word probate. The word probate is actually one word that defines the entire process of taking the will and putting it on record to the settlement of the estate. So the minute the executor comes into being is the minute that you pass away, and the executor takes the will It's now in his or her possession, and it goes to the courthouse, so you are appointed executor. Once you're appointed executor, you get little certificates about this big with seals on them and so forth.
Right.
Those are your ticket. You now are in the place of the deceased person. You can walk into any bank and they open up all the drawers for you because you're the executor. So you then use your appointment as executor to put the estate together, to bring it all into the pot, to pull it all in, put it on his table, and figure out what dad or mom had or uncle or aunt had if you're their executor, what assets they own, what cars they own, what real estate they own. You've got to find their life insurance policies and put all this onto the table and define what it is. And then that way you can pay the bills, because your first and most important job as executor is to pay the bills. I'll tell you what, I'm wrong. The most important job you have as executor is a fiduciary obligation to protect the beneficiaries of the estate.
What does that mean?
Job.
What is fiduciary obligation?
Fiduciary obligation is a fancy phrase that says that you, as executor, are to protect the beneficiaries. If you're one of the beneficiaries, you're no better than anybody else. Executors have a tendency to think, especially in this situation, you have 5 kids. Oldest brother is the executor. His parents routinely appoint oldest child as executor, and they shouldn't, but they do. And that's an old wives' tale, too.
You should appoint your best child as the, and let's not get into trying to figure out how that works.
And, but the executor then, for some reason, thinks they're special, that they should somehow have more powers and they should have first choice of assets and that kind of thing, and they don't. It actually works the other way around. They are now in a position where they have to protect every beneficiary of that estate and make sure that the bills are paid and they receive their estate equally, just like everybody else. So the executor takes an oath of office to uphold the Constitution of the United States, the state of West Virginia, and to protect those beneficiaries. They then put I'm back to my pot, they put everything into the pot, they then pay the bills. There's a way they have to pay the bills. They don't get to pick and choose which bills they want to pay. The state of West Virginia says which bills will be paid first, and guess what the first bill is that gets paid? The funeral bill. You know, the code says we're going to take care of the funeral bills first, that kind of thing, and we're going to take care of certain secured liens and that kind of thing, but it's all defined. And so the executor then takes over, does those things, protects the property. If it's necessary to lock the house down, change the locks to protect the house, they do that. That's kind of some of the functions of an executor.
The fiduciary duty that we talk about that the executor has to the estate is the highest duty. The executor has to take care of the estate before she or he takes care of themselves or anybody else. A parent, if they had a sandwich and a child, and both you and the child are starving, the parent will give the sandwich to the child. That's very much what a fiduciary interest is. Before you eat, you make sure that your child eats. In dealing with an estate, you have a fiduciary duty as the executor of the estate to make sure that the estate is taken care of before you are taken care of. If you only have 5 minutes to do something, you do something for the estate before you do it for yourself. There is no higher duty, and people frequently get confused about that.
You're exactly right. They think they're special. They think they're higher up. And for some reason, they think they get to pick first. I have never understood why executors think they get to pick first when they're going through and selecting items and dividing up the assets, but a lot of them think that way.
Does the executor get paid for all this?
There is a formula in the code, the state of West Virginia code, on this. There's a formula, and the more the estate is worth, the less you get paid. It starts out at like 5% for the first so many $100,000, and then if it turns into millions of dollars, then it goes all the way down to like 1%. In the old days, it was a flat 5%. So if you had a $3 million estate that was all CDs, then the executor really cleaned up because they got 5% of $3 million for basically cashing in CDs. So they obviously our legislators thought that was unfair, and they rewrote the law. And that rewriting came out of the West Virginia State Bar Probate Committee, where all those specialists that are in probate law got together and came up with a formula that they thought was more fair, and it was passed by the legislature.
Yeah, that doesn't mean you get less money the bigger the estate is. It means you get a smaller percentage of the estate the more valuable the estate is.
As a commission.
As a commission for serving as the executor, assuming that you do your job completely and correctly. If you drop out, or if someone comes in and has you removed, your compensation as executor is going to be affected by that, and you may find that the county commission is the one who's telling you what you're going to be paid for the incomplete job you did. Conversely, if the estate job is much, much more complex and the executor incurs expenses and outrageous amounts of time to get things straightened out, as if perhaps you have warring heirs who want to argue about everything, your compensation might be approved to be a little bit more too. So it's kind of a moving target, but there are general rules that apply. But the important thing to remember is the executor does not work for free. So when you pick your executor, make sure it's someone who is reasonably competent to do the job and reasonably diligent to make sure that the job is done and done correctly. Probate itself is not a terribly complex operation in West Virginia.
It is not. Probate is basically, as I said, it's the whole procedure, but the procedure is actually a couple of steps, or about 4 steps, and it's not that bad. The first step is recording the will. You do not record the will until you pass away, until the person passes away. Often people think you're supposed to sign the will and take it to the courthouse, and you don't. So once the person passes away, step 1 is to take the will to the courthouse. Step 2 is to get the executor appointed, probably without a bond, and I get that one all the time too. I want to make sure my oldest son doesn't have to post a bond. Number 3 is you then prepare an appraisal. The appraisal process, everybody is scared to death of it. They think you have to hire appraisers and you have to bring in experts to value the real estate and bring in experts to value the personal property, and you don't have to do that unless it is a contentious estate. And then step number 4 is, after you've done all of this and you've been paying all the bills and you're doing the big pot I was talking about, step 4 is the final settlement. The final settlement is where you reconcile and prove to all of the beneficiaries what you have done with everything. Every dime that's come in and every dime that's gone out, where is it and how did I spend it? How did they spend it? And they have to put all of this on a form, obviously, and it gets mailed to everybody. Everybody who's a beneficiary gets to see where it all went, so they know that the bottom line, what they got from the estate, is their fair share.
Now, when you value the estate, there are some circumstances under which you might want to have real estate appraised and things of that sort, but those are exceptions to the normal process. For example, if an estate needs to be divided up equally among a group of people, but certain of the assets are going to pass to certain of the people, you may need to value those assets to make sure that the others get their fair share. Similarly, it may be advisable to value real estate because of what happens when the real estate is sold in subsequent years. You basically need to know what the value of it was at the time it passed to you. But that's oftentimes as much the recipient's obligation to value the real estate as it is the estate's obligation to value it. So these are reasons why you may want to talk to a lawyer. Why can't I just go get a will kit or a form off the internet? Those things are tested and ready to go, aren't they?
Oh boy, now you've opened it up. I absolutely detest will kits. I cannot begin to tell the public, and you brought up you've opened up Pandora's box with will kits. There is nothing more dangerous in planning what you want done with your property when you pass away than a will kit. They are absolutely lethal. They are lethal. Do not, under any circumstances, use a will kit unless you take it to a lawyer and have them review it and make sure you did it correctly. And I had that happen just a week or so ago. And this is a professional, a school teacher, brought me a will kit that he got off the internet. He has infant children, 4 infant children and a spouse. He brings me a will kit that he had printed off, that he had filled out, and wanted me to look at it and see if it was done right. It was totally, absolutely done wrong. He had done nothing right in it. As I talked to him, he wanted his children to get their estates when they were 23, 25, that kind of thing. In his little will kit, he had them getting it at 18. It was a trust will to boot as a will kit. It wasn't signed at the bottom of any page, so who knows where those first 4 or 5 pages came from. He then signed it. It wasn't dated. They didn't figure out the top of the page, the last page had a date line. They missed it, so it wasn't even dated. There was nothing about that kit that was done right. You know what I tell people about will kits? I said, I actually like will kits because I'm going to make a lot more money, and you're going to make a lot more money if we get into a big will contest case, and we did some time ago, about a year ago, where we contested a will kit, had hundreds of thousands of dollars at stake, and we made lots of money, thousands of dollars in that case, as opposed to $100 for a will, or $125 for a will. So I'm going to make a lot more money in that litigation than I am doing wills. I say that tongue-in-cheek because, for instance, that $300,000 estate, they did a will kit. They changed their minds. They didn't get legal advice. So when they went in, they took some white out and whited out stuff on a will kit. So of course that made it. that it was bad.
There are technical rules for how documents are interpreted, about when documents are valid. There are very specific rules about how wills are to be formatted, signed, witnessed, that can lead to just absolute disaster. A note on the back of a napkin is not a will, even if your best friend tells you that it is. Don't copy somebody else's will. Don't presume that because it's a kit that you buy at a business supply store that it's been reviewed by anybody in your state or is legally competent for any reason. If your estate is important enough to you to cause you to worry about who's going to get what, you need to talk to an attorney about having a will prepared. It doesn't have to be expensive, just a few minutes to determine what you want to do. Rob Fisher, thank you for being with us again.
Glad to be here.
Thank you also for being with us. On behalf of the Law Works, I'm Dan Ringer. Good evening.
If you want to know if you need a lawyer, you can discuss your problems with a lawyer by calling the West Virginia State Bar Helpline, toll-free, Tuesday evenings from 6 to 8 at 1-800-642-3617. On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks show topics, information on how to obtain copies of the programs, and additional information about this show's topic. You'll also find a list of legal resources that can help you answer your legal questions. If you'd like to recommend this program to a friend, you'll also find video of this program on thelawworks.org. If you would like to suggest a topic for a future The Law Works show, or if you're a school teacher and would like to receive a copy of this program for classroom use, please send us an email to thelawworks@comcast.net.
The Law Works is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The Law Works is made possible by the generous support of the West Virginia State Bar and the Monongalia County Bar Association.
From West Virginia Public Broadcasting.